So good evening everyone. Thank you all for being here. My name is Julian. I'm a mediator today. So we're here for an intellectual property dispute. The claimants are claiming that OmniAI and Microsoft have used their articles and novels to train their AI language model without the permission. But before we start off, could I just have your signatures on the mediation agreement below? And now, before we dive deeper into the session, could we just briefly introduce ourselves? Let's start with the claimants.
Hi everyone, I'm Grisham. I'm a novelist.
So hi everyone, my name is Denise. I'm the Vice President and Chief Legal Officer of the Daily Ledger.
Hi, I'm Dr. Jabbour. I'm from Macrosoft and I am the Innovation AI Officer.
Good evening everyone. Hi, I'm Asli and I'm the lawyer for Microsoft.
Greetings everyone, I am Joon, CEO of OmniAI.
Hello everyone, I'm Singh and I'm the legal counsel for OmniAI.
Thank you everyone, I hope everyone is living a little bit more comfortable with each other now. But before we begin, I just want to walk you through the process and some ground rules of our mediation today. Now, mediation is a very voluntary process where I will act as an impartial facilitator to help you communicate and negotiate a commonly agreed outcome. So any party may withdraw at any time. My role as a mediator is to facilitate communication. I am neutral, I take no side, I will not judge who is right or wrong. I won't impose any decision, and any agreement reached will be by own consensus. I also have no stake in the outcome. Now, throughout the process, I may ask questions, I may reframe what I hear, and help clarify the issues. When discussions become tense, I will intervene to keep us on track. I also ask that we all remain professional and calm and respectful at all times, and avoid interrupting each other. We'll all have a chance to speak and be heard. We are conducting this mediation today under the AIAC mediation rules and in accordance with the Mediation Act 2012. We have all signed the mediation agreement earlier at the start of this session as required by Section 6 of the Act. This means that everyone has formally agreed to mediate in good faith. Well, I also want to emphasize on confidentiality. Everything we discuss here is private and confidential, protected by the law. According to Section 15 of the Mediation Act, anything said in this mediation cannot be used in court as evidence and cannot be revealed to others. But this allows us to speak more openly. Also, under the AIAC mediation rules, any information shared with me in the private caucus later will remain confidential unless you permit me to discuss it. If at any point you wish to speak to me in private, you may request a private caucus, we can do that. And then such sessions are also confidential. We all share an interest here today, I believe, from keeping this dispute for public attention, given the sensitivities of all the parties involved. Well, the process of today's mediation will be this. First, each party will have an opportunity to make an opening statement to explain your perspectives and problems. And after that, we'll identify key issues and set an agenda. And then we will then move on to an open joint discussion to discuss those issues. And finally, if you reach any understanding, we'll work towards a settlement agreement which will be binding on all parties. If at any time you need a break, do let me know. Are there any questions before we begin? Great. Let's proceed then. Let's start with Ms. Grisham and Ms. Ananth with your opening statements. Please briefly tell us what brought you here today.
Thank you. So, I've been a novelist for many years and I've had 38 consecutive #1 best-selling fiction novels over my career. I appreciate the chance to speak here. Frankly, I'm deeply upset and concerned that my copyrighted novels have been used without my consent to train an AI model. I pour my life into my work. My stories are my livelihood and also my legacy. So I was so shocked to discover that Microsoft AI, they can produce full passages of my novels and someone prompts it, the AI just like from word for word. So this has affected my book sales and also my income. So since their AI was launched, I've seen a notable drop in sales of my novels. To an author, it feels like my work, my intellectual property has been taken wholesale. I believe this is because people can get content similar to my books from the AI instead of purchasing my books. So I have friends telling me that they saw summaries or chunks of my novels generated by AI online. It's frustrating. It's not just about money, it's about respect for my rights and also creative effort. So in my view, what Microsoft has done is nothing short of theft of my creative expression. So we have sent a letter of demand in August seeking 650,000 for each of my works that was used without permission. I'm here in good faith. What I want from this process is accountability and also fairness. I'm looking for compensation for the losses I've suffered and assurances that this won't happen to me again. So I truly hope we can resolve this here, because I would rather not have to fight this out in court. But I will if I must, not just about for me, but also for the other writers.
So I'm the Chief Legal Officer of Daily Ledger. So the Daily Ledger is actually a very respected newspaper. We invest heavily in journalism and quality reporting. So like Jennifer, we were shocked to learn that thousands of our news articles were apparently used to train AI models without our consent or any compensation. So the AI outputs are strikingly similar to our reporting. This threatens our business model and our reputation. We rely on subscribers who trust our content. If an AI is giving away writing based on our articles, why would people subscribe? In fact, we've already seen a decline in subscribers number on our online and print editions. So this undermines our credibility. If the AI writes something similar to our investigative pieces, it could have caused confusion about the authenticity. We join Jennifer in calling this a systemic theft on mass scale. We are contemplating a representative legal action, not just for us, but to set a precedent for all content creators, especially for journalists. However, we do recognize that the value of resolving this privately, if possible, we demand 650,000 for each affected article. And our goal here is to stop the unauthorized use of our content and to be compensated for the harm. We also want assurance that our intellectual property will be respected moving forward.
Thank you, Ms. Jennifer and Ms. Denise, for your clear explanation. I understand the frustration and that you feel that you have extensive use of these unauthorized materials, causing great financial harm, and your rights have been infringed. And we're now seeking significant compensation, I believe, if I understand correctly, 650,000 per work, and guarantees against future misuse. You've come with a serious intent to mediate, and this is backed by considerable external support. Dr. Sandy and Mr. Rizal, I now invite Microsoft to do your opening statements. Perhaps we can start with Dr. Sandy.
For Microsoft, we understand the concerns raised by Ms. Jennifer and Daily Ledger, and we do take intellectual property rights seriously. So I want to clarify our role. We did not directly train the AI model on our works or your works. Instead, we licensed a foundation model from OmniAI and built our applications on top of it. So in other words, the AI underlying training data and algorithm actually came from OmniAI, not from our own development. Our agreement with OmniAI actually assured us that everything was transparent and lawful. We did not intend to harm anyone's rights, and regret if our use of the AI model has indirectly caused distress. So the reason we deployed the AI, our goal was to innovate and serve our users, not to undermine authors or journalists. We are here today to find a solution that addresses the claimant's concern while allowing us to continue our work. However, we must also protect our interests, as this dispute could actually affect our reputation globally if it escalates. So we want to avoid that. We hope to resolve this amicably.
Right, so just to continue where Dr. Sandy left off, legally speaking, Microsoft's position is that we are not liable for copyright infringement because we neither selected nor directly used the claimant's content in training the AI model. And if that responsibility, if any, lies with only AI as the developer of the model. And if this were to go to court, we will argue that Microsoft itself did not commit the alleged acts. We did not supply pirated copies of books or articles to the model. However, that said, we do recognize that practical risk of litigation for everyone. A public lawsuit would be costly and could damage business relationships for Microsoft, Ms. Jennifer, the Daily Ledger, and the fact that claimants came to mediation instead of immediately filing a suit in court, we do appreciate that. However, we must also ensure that any settlement is confidential to avoid drawing negative publicity. Both Microsoft and OmniAI are concerned about reputational damage if this were to become public. For example, OmniAI's pending IPO is a significant factor, and any hint of legal trouble could affect the process. And likewise, we have ongoing partnerships and licensing deals that we don't want disrupted. Therefore, we came to mediation in good faith to see if there is a mutually acceptable outcome without any admission of liability on Microsoft's part.
Well, I think we understand your position and your concerns, but let's hear from OmniAI's representatives.
Okay, so Mr. Jordan, to begin with, at OmniAI, we value innovation as well as respect the creative community. However, with that being said, we maintain that OmniAI did not steal any content, as the training procedures for our content were aligned to the principles of fair use and dealings, which were intended to transform available data into beneficial technology instead of infringing upon copyrights. With that being said, however, we are aware of the concerns raised by Jennifer and the Daily Ledger, as well as the fact that our IPO is approaching. Therefore, we would like to resolve the dispute responsibly, as well as avoiding a public litigation is priority to us. Therefore, we are committed towards listening and exploring a mutually beneficial solution.
Yes, so legally, as what Mr. Julian has already said, we maintain that there's no infringement occurred under the law. We are fully prepared to argue in court that using the claimant's materials squarely falls within the established allowances for fair dealing as well as for data analysis. There is in fact precedent in some jurisdictions that such use can be lawful, especially where, as here, this model does not publish the original works verbatim, but instead generates new content. That being said, litigation is still inherently uncertain and could be damaging for all parties. We acknowledge the risk of bad publicity and the cost involved if this also goes to court. OmniAI is also concerned about maintaining the trust of our investors and partners in light of the upcoming IPO. And we came to this mediation today to see if there is a pragmatic solution, perhaps even a business solution, that addresses the claimant's concerns without undermining our position as well. We are open to creative solutions as well, such as licensing arrangements or even other forms of settlement.
Well, thank you, Mr. Genevie and Mr. Singh. However, I just want to stop you there and just remind you that the purpose of this mediation today is not to determine whether there was infringement under the law or to decide on legal arguments, but rather to find an amicable solution or a common ground to resolve the dispute or take into consideration the interests involved by all parties. But I also want to thank you for your candid opening remarks. I really appreciate everyone's professional tone.
Now that we've heard from both sides, I've also taken notes throughout the process. I just want to try and summarize the main points and make sure that we're on the same page and to set our agenda today. So I noticed a few key issues. First, intellectual property concerns. The claimants allege that their work, Jennifer's novels and the lecture's articles, was used without consent and compensation to train an AI. They assert that this has led to AI reproducing substantial portions of their work, infringing their IP rights and causing them financial harm. And while you guys, the respondents, contend that they have not violated the law, and Microsoft pointing to OmniAI as the source of the model, with OmniAI claiming fair use. Our second point is financial compensation. Jennifer and the lecturer seek compensation for the unauthorized use of their works, citing 650,000 ringgit per infringed work in their demand. Now, taking into consideration the sheer volume of work involved, this amount could be very large. They see this as a compensation for losses and as a deterrent for mass IP theft. Now, Microsoft and OmniAI are worried about the cost and setting a precedent that paying such claims, especially if they believe they did not break the law. They have indicated willingness, however, to consider a more reasonable approach, a reasonable aggregate settlement, but nothing near your initial demanded sum. So a major agenda today, I believe, is to negotiate a financial settlement figure or a formula that both sides can accept. Now, the third point is reputation and future conduct, which I believe is of importance to all of the parties here today. Now, everyone is concerned about reputational damage, and the claimants particularly are worried about this reputational damage to their professional credibility and this continuing loss of income. Microsoft and OmniAI feel global reputation harm and business impacts if this escalate. Now, there is also this looming possibility of public disclosure by writers, unions, and the press if you do not reach a resolution today, as well as the effect of OmniAI's IPO, I believe. Additionally, a consensus may be needed to handle how the AI model use or doesn't use the claimant's works moving forward. Thus, any resolution today will likely include a strict confidentiality clause, and there is a shared interest for this here. Now, to resolve this quietly and to avoid public sensation, now we should list then what confidentiality measure or joint statements we would want to go with moving forward. The last point I have is relationship and confidentiality. Finally, it seems all parties would prefer to resolve this matter privately and maintain a working relationship with each other, if possible. The very fact that we are in mediation right now means everyone wants a confidential and amicable solution rather than a public fight that doesn't benefit anybody. Does that summary capture the main issues from everybody's remarks? Very well. Now, if we could just move on and set our agenda today. I think if we narrow down those things into 3 broad topics, it would be very helpful. What I have is this. Firstly, again, compensation and remedies for past use of content. What, if anything, can be done about the alleged past unauthorized use of the claimant's works. This may include financial compensation or any other remedial actions. Second, future use and safeguards. How can we address the claimant's concerns moving forward? Forward-looking aspect. This might cover whether the AI model will continue to include their works, possible looking at licensing arrangements and permissions, and how to protect the claimant's intellectual property and interest in the future. Now lastly, the PR and confidentiality aspect. What can be done to manage reputational concerns that we both have? For instance, do the parties want to agree on confidentiality terms, a joint statement to prevent a public fallout, and ensuring that after today the matter is settled, sealed, and remains confidential is important for both sides. Does that agenda sound agreeable to everyone?
Yes.
Great. Let's proceed with the joint discussion phase. Let's start with the first item then, compensation and remedies for past use of your content. Now, from the opening remarks, we've heard your positions on compensation. The claimants quantified the demand, and the respondents have some concerns about that. Now, since Jennifer and Denise, you raised the claim for compensation, would you like to elaborate or clarify what you're actually seeking?
Certainly. In an ideal world, for me, they will pay for what they have done, a sum that I think reflects the scale of the violation, and they will stop doing it. So as we stated, we asked for 650,000 per work in our letter of demand. I think this figure represents the value we place on each novel or article that was used. To give context, some of my novels generate significant royalties, and the Daily Ledger articles can have considerable commercial value as well. So the sum was also meant as a deterrent against unauthorized use. But I do understand in this mediation we might not get everything, but we are open to discussion. So for us, it needs to be a substantial amount that reflects the seriousness of the infringement. We didn't come up with this number like this.
And additionally, I want assurances that OmniAI or Microsoft, they won't use my existing or future writings without permission. Perhaps that means purging my novels from their training data, if that's even possible, or at least a promise not to include them in any future orders. And perhaps a system that authors can opt out of having their content used by AI systems. I realize that's more forward-looking, but I think this case can be a precedent. And emotionally, I guess I also appreciate the apology or acknowledgement of wrong, but I'm realistic they might not formally admit their fault. So if the compensation is significant and there are concrete steps to prevent a repeat, I can live without a public apology. So what matters to me is that this hurts enough for them that they and others won't just do it again casually. So, and I'll just be honest, if we can't get something along those lines, then I would rather just let the world know about this and fight out. But I hope we can get there today.
Yeah, I think for the Daily Ledger side, we considered the damage and to our business and the reputation of our business as well. And we need a settlement that's big enough to justify not going to court, our board and our unions will ask if it's a strong deal. And we did indeed actually anchor the anchor high with 650,000 for each article, expecting negotiation. But as Jennifer said, we won't walk for pennies. We also need like future safeguards. For example, if OmniAI could implement a mechanism to filter out the daily ledger's content from its training data or from its output, we want something in writing that they will not include our articles in any current or any future training without a license. So perhaps Microsoft and OmniAI could also offer us a formal license agreement for the content, meaning that if they want to use our news in their AI, then they have to pay a license fee for it.
Confidentiality is also actually very important to us. So if we get a good settlement, we don't necessarily want it to be public as well. So we are prepared to agree to strict confidentiality, both sides where we don't disclose the terms and even the facts of the settlement beyond a very generic statement. So that's one area we will likely agree on. So yes, those are ideals: significant money, protective measures, confidentiality, and moving forward in a way that our rights are better respected.
Okay, thank you for clarifying. So from Microsoft's perspective, that amount is too high. If we total up the works, the demand reaches into multiple millions, and that is not feasible. Moreover, from a legal standpoint, even if liability were established, damages would have to be proven. For instance, actual loss in sales attributable to the AI, and we would dispute that such a high valuation in court. That said, we are prepared to discuss forms of compensation, but it must be reasonable. Microsoft did not earn direct revenue of Jennifer's books or the Daily Ledger's articles, so we use the AI internally and only for some customer-facing tools, but not to sell the content outright.
I would like to also put it out there that OmniAI also finds the demand disproportionate. In fact, the AI was trained on a vast data set, so the inclusion of the claimant's materials was not personal, targeted, or even deliberate. It was simply part of an automated web crawl or data collection. So, in our view, any use of their content was merely incidental. This is certainly not something OmniAI profited directly of their specific works. We understand, we feel wrong, but we must also consider that, the law might set us here. And if this goes to litigation, well, there is a real chance the court could decide that there's no infringement occurred, or even the damages are minimal. We are all here today because we all want an amicable solution. But at the same time, we also need to be realistic.
Realistic? From whose perspective? Are you kidding me?
I just want to intervene here and just remind parties to keep a professional tone and just be more understanding to each other. I just try to remind again also that let's focus on the issues that are concerned here rather than the legal arguments. Ms. Jennifer, are you ready to continue?
So, from where we stand, our works were used, and you benefited from them in training your product. Maybe you didn't sell my novel outright, but your AI being more capable because it ingested my novel does benefit your product, and it certainly helps me. So you say incidental, but it doesn't feel incidental when my entire book can be reproduced by the AI model that you on request.
Yeah, actually, what she said was true. We came to this talk to actually talk things through, and you calling the use of thousands of our articles as incidental honestly feels very dismissive. Our work isn't some background noise. It's a big part of what helped to make your AI as good as it is. So when your system produces articles that looks and sounds strikingly similar to ours, that's not random. That's our voice, our judgment, and our effort showing up in your output. So saying that you didn't sell our article misses the point. You still benefited from them in a real way. Our work helped improve your product, and the value didn't disappear because it wasn't sold directly. So from that perspective, offering a token amount feels like you're not taking this seriously. We're not asking for a gesture, we're asking for a payout that actually reflects the scale and impact of how our work was used.
Yes, we hear you. Perhaps incidental wasn't the best word, but the point is, we did target your works with the intent to steal. This is an unfortunate side effect from how AI models learn from large data sets. So we are open to compensate you to resolve this. But I think the amount should be something that we can specify, because we also have to consider fairness and consider if you pay an extremely large amount, it may invite you and also invite others to come and claim from OmniAI and Microsoft anytime for similar claims.
Exactly. We need to look at the future here. If we set a precedent here, OmniAI could face a flood of claims from every author or every publisher in this training area, and we cannot afford to open a floodgate. However, we are here to make things right to our best extent possible.
Yeah, I just want to reassure everybody that I'm hearing all of the concerns, but I do see that we have strong feelings on both sides of this issue. And it's totally understandable, it's a complex issue. I suggest, how about we take a step back? Both sides have valid concerns. The claimants feel that their lives, work and livelihood is compromised at stake. And the respondents on the other hand are concerned about setting a sustainable precedent and not admitting to wrongdoing. So to me, now is a good time, a good juncture to pause our joint discussion and break into private caucus sessions. That would then allow us to speak more freely, and you can speak to me confidentially about your concerns, any if you have, and maybe your flexibility in how to reach that consensus. And after that, we can resume and come back together and hopefully move closer to that middle line. I'd like to then start the caucus with the claimants, Jennifer and Denise. Microsoft and OmniAI team, you can take your leave from outside the room and take a break. I will come and speak with you shortly after I finish with that. Remember, again, these one-on-one discussions are strictly confidential. I will not disclose anything you tell me unless you tell me to. Okay? Thank you, Ms. Jennifer and Ms. Denise, for speaking and meeting with me alone. I just want to remind you again that everything you say to me here is between us only, and it's confidential. I won't share it with the other parties if you do not want me to. Well, my role here is different from the joint discussion. I am here to act as a sounding board. You can tell me everything, and maybe I can help figure out and do a reality check to help figure out how we can get the best outcome and how far are we from that. So, you want to tell me how you're feeling about the session so far?
It's a bit tiring, honestly. Hearing them talk about fair use and downplaying things by calling it what incidental was frustrating. But I'm glad we are at least talking. I do feel that they are quite concerned about their image, which I think is leverage for us.
Yeah, I agree. They're definitely here because they're scared of a fallout. So I guess that will work in our favor. And I'm actually quite optimistic that we can get a good deal out of this. But my only concern is that I'm scared they will try to lowball us out on the money. So that's one of my concerns.
Yes, I get the concern. It's understandable. I think it's a valid concern. Now, this is also a good opportunity for us to discuss what your true bottom lines are when we're talking about the amount of compensation, right? And what flexibility you have for it. Now, sometimes in joint sessions, parties might want to keep something to themselves. They don't want to disclose everything. I get that. But here you can be frank. Now, my job here is to figure out where there is overlap between what you can accept and what the respondents may have to offer, and then we can see where we can go from there. Now, I understand that you feel that your work has been taken advantage of, and you're not just seeking monetary compensation. It's not just about money, right? You also want respect and assurance that this won't happen again to you. Is that fair for me to say that?
Yeah.
Yes, honestly, I feel violated. My novels are like my children. Knowing they were used without permission is not just about money. Money is a tangible way to measure the harm, but it's also about principle.
Yeah, I guess for the daily ledger we will agree to that. It's not just purely about money, it's about our reputation and sustaining our business model. So if an AI can just use our content, it undermines the whole industry of journalism. We also need some clear acknowledgement from them of like what happened was actually wrong for them to do so.
Yeah, I hear you both. It's very important to acknowledge these things as well. You both value your intellectual property and want that to be acknowledged and protected.
Yes.
And at the same time, you want appropriate compensation, monetary or otherwise, for the harm that's been done to you both. Now, you came to mediation. We suggested you want a negotiated solution over litigation. And I'd like to discuss those alternatives here as well. Now, think for a moment about what happens if you don't settle today. Now, Your alternative is likely pursuing a lawsuit, go to court, maybe a large representative action with support from other people you've mentioned just now. You mentioned having a writers union and press advocates ready to back you. Now, okay, that will indeed give you put public pressure on companies to resolve this. And however, consider the timeline and outcome of that litigation. It could take years in court, very long time, and it will be very expensive. Now, even with that strong support you mentioned, there is no guarantee how the court will decide. It could go either way. And that using AI data for AI training is still a grey area in the law. Now, if the court ruled against you, say, on liability, you could end up with nothing at all. And the AI companies would feel vindicated, and then they will continue using your works. Now, that is what we call a worse alternative to a negotiated agreement, or we call a WATNA. Now, a legal defeat after a long and public battle, which might also be emotionally draining for people like you, and could expose your work to even more vulnerabilities and dangers in the process. Now, on the other hand, if you go all the way to trial and win, now that's your best alternative, a BATNA. Now, perhaps you get a judgment for damages. The court will order the companies to pay you a substantial amount. But think about enforceability and the appeals. They might appeal the verdict, drag it out, and even if you win the money, the relationship is destroyed. There's likely no way you could work with them again. And everything becomes public record against you. You might also have to withstand intense public scrutiny. All eyes will be on you. Sometimes big tech companies fight back in the media during lawsuits. So those are things you might also want to consider.
Yes, true. I think one thing that I've considered is that even if we win, it could take a very long time, and the fight could get ugly.
Yes.
So, and at the same time, the infringement will still be ongoing, unless we have like injunction to stop them.
Yeah, actually I do agree with that. But also an IPO means that they might actually settle if we pressure them. But if they choose to fight, then they could try to wait us out with their resources. So it's actually quite risky for us as well.
Now, exactly, that's a very good point you mentioned. So people come to mediation because mediation offers a chance to get something fairly quickly and concrete. And at the same time, you get to keep it private, out of the public eye. And you mentioned earlier about principle. Sometimes an agreement can include not just the monetary aspect of things, that address things like you said, principle, maybe an apology or changes in how they do things. So let me ask you both this. Aside from the exact dollar amount that you're claiming, what is most important to you that you want to achieve here?
For me, I think it's the most important thing is that they stop using my novels without my permission. Money is part of it, and yeah, because there's been loss. But I think I will be more at peace if I know that they won't misuse my novels in the future. So I think an acknowledgement of wrongdoing, even if it's not public, would also mean a lot to me.
Yeah, I actually do agree because we do need compensation to cover, our losses and to signal that using our content has consequences. And possibly moving forward, maybe a license agreement, or where OmniAI and Microsoft can enter a paid license agreement to use certain contents of the daily ledger with specific terms, of course. And we're not just trying to prohibit the use, but we might move forward to monetizing the use. But if you prefer to simply not use our stuff at all, then that will be fine too. So we just want to stop the uncompensated use, and yes, some sort of apology or responsibility taking, even if confidential, would just help us feel validated.
Yeah, thank you for telling me that. That's actually very helpful because it sounds like you also want future protection and recognition, and they matter just as much as the money that you might get. It's very helpful to know that because if the other side offers something slightly lower than the initial numbers, but they include something like a commitment to respect your IP going forward, or like removing your content and licensing it properly, and maybe a formal apology also. Would you consider those things?
I guess we would consider it, but it depends on how low the amount is. Because we do have to answer to our supporters and the unions and other people, so on why we settled for such a low amount. But
if the terms clearly protect our rights and the process is confidential, then I think might be acceptable to us.
Yeah, we are not here to kill their business. We just want fairness, right? So if they show that they are serious, then we can be flexible. Perhaps a lump sum settlement, or this lump sum settlement have to be significant, but not every single work at full price, along with an agreement on how our content will be handled moving forward.
Okay, I understand that. Also, could you give me an idea of the range of the settlement that you could accept? Of course, I won't disclose this to the other party, but it's just to help me to gauge where the common ground might be, and that will help us to move this mediation forward.
Yeah, actually internally, Jennifer and I actually talked about it, and we might be prepared to accept a global settlement figure that doesn't follow the sum of 350,000 per work as we mentioned earlier. But for instance, this is just for discussion. If they were to offer something within the range of, let's just say, a few million ringgit and total combined for both of us, then we would seriously consider it, but provided that the other terms, such as future use and apologies are there, then I guess we're fine with it.
Yes, I think the money should feel like a real acknowledgement. So even if it's not as high as what we stated in our letter of demand. So also, I think anything that is non-monetarily that benefit us, like for example, maybe a collaboration or a licensing deal for the future use, it could be interesting too. So, but primarily, I think the most important thing is that we want a solid payment and also assurances that they won't use our work unauthorized again.
Okay, that's very clear. And I thank you for your honesty for telling me that. Now, I just want to confirm, are you comfortable with me keeping this figures confidential for now? I can use this to understand and to guide the other side without revealing your actual figure bottom line.
Yes, please keep it confidential.
Yeah, we do trust you to convey the essence without giving the exact bottom line unless it's necessary.
Of course, I'll do that. Just one more thing. If they do agree, say, to remove or license your content properly and possibly include a private or maybe public apology, and that will satisfy your non-monetary aspect, right?
Yes, I think a private written apology or maybe a statement that acknowledge our rights, it will suffice. If public, then I think it's even better, but I doubt they will do it publicly. So, but for us, I think at the very least, we want them to acknowledge it in writing in the settlement.
Yeah, and then I would think for the daily ledger will be more on the removal of our content from the AI, and also a license agreement, for to use our content. We just don't want to be exploited, moving forward. So yeah.
I understand that, and it's been very helpful today's caucus. I will now then speak to the other side first and see what we have there. You guys can take a short break, and then we'll reconvene in the joint session soon later. Again, I want to assure you that everything I share and you share with me here is in confidence. I won't disclose it unless you allow me to. I'll just now gauge their willingness and maybe carry a proposal that they have and see if it's acceptable for you guys later.
Yeah.
Yes.
Okay?
Yeah,
Thank you.
Thank you very much.
Thank you very much. I appreciate your patience, and also thank you for taking the time to speak with me privately. I also repeat this again to ensure we're all on the same page. Everything you say here remains confidential with me. I will not share it unless you allow me to. Now, my role here is very different from the earlier joint negotiation. Here, I'm helping you to explore your flexibility and see how you can reach a solution that you can accept. I think first, the most noticeable problem is that Microsoft and OmniAI are actually two distinct entities with potentially very different concerns. Are you all on the same page? Or do we need to address any differences between the companies?
Actually, I believe we do have a common interest in resolving this, but there's just a bit of question in terms of responsibility sharing. So for our stance, OmniAI being the moderator, they should bear the responsibility, if any. But then again, for the purpose of settlement, we are willing to contribute to a solution since our product deployment actually triggered a complaint. So we've discussed internally and we agreed that we are willing to also contribute to the settlement cost for some proportion, so long as it is reasonable. But that's between OmniAI and us.
Yes, OmniAI and Microsoft have actually spoken and we will coordinate accordingly. So we won't let the issue of who pays what derail the mediation. And if the deal makes sense, we can just sort out privately to essentially know how we can split the payment. But for now, what we want is to just minimize the total cost and exposure for both of us.
Yeah, well, that's good. And it's great to hear that you are both cooperating, and it's very helpful to process. Now, my question is this: what is your main concern in this dispute? So, from the opening statements earlier, I gathered a few things. So, you want to avoid a large payout. You do not want to admit legal liability. You want to prevent a public spectacle, especially with unions and media possibly getting involved, and keeping OmniAI's IPO on track with no litigation hanging over it. I think that we understand that. And also, broadly, to preserve Microsoft and OmniAI's reputation and business relationships. Is that accurate? Anything you want to add to that?
Okay, that's accurate. Reputation and business continuity are paramount, and we want to avoid any outcome that sets a costly precedent or encourages others to actually use claims against us. So also a drawn-out legal fight, especially one attracting media attention, would be very, very bad.
Now let's talk about that scenario a little bit more. What if you don't settle today? Your best alternative to a negotiated agreement, what we call a partner, is that you might go to court, possibly get your case dismissed if you win on a legal argument that there is no infringement in the law, like you mentioned earlier. But do consider the broader picture. Even defending the case in court means that the issue becomes public. Jennifer and the letter have public support from international writers group and press advocates who could broadcast this issue, which is not good. It could spark public debate about AI and copyright, potentially casting Microsoft and OmniAI as villains in this, what we call a court of public opinion. That could scare partners, that could scare consumers, and of course, for OmniAI, IPO is coming soon, and that could derail the process. Underwriters are watching closely for any litigation that might affect this. Now, turn then to consider your what we call a worse alternative to a negotiated agreement. Now, if this goes to trial and you lose, say, the damages could be enormous, far more than what you could have paid today, especially if it's per work multiplied out. It may also force you to stop using large parts of your training data or your data set you're currently using, and set a legal precedent that requires you to, say, obtain a license before you could train AI, which could disrupt your entire business model. This is not what you've been operating on. Now, the cost here is not just financial cost. Consider also the regulatory and reputational cost that might come with it. What do you guys think?
Those are good points. Even a win in a court will still hurt us, as the process could tarnish our name or worst off invite regulations. Needless to say, a loss will be disastrous for us.
Yeah.
Yes, exactly. We lawyers think we have a strong case, but at the end of the day, any litigation is a gamble. And this case is especially so because this is something new. And as mentioned by Mr. Julian, public relations damage might already be done by the time we get the result.
Yeah. So I think it seemed clear that a private settlement here could save a lot of our trouble for all of us. So the question then becomes this: how much or what are you willing to offer to make this problem go away? It needs to be, let's be realistic, it needs to be enough that the claimants feel respected and compensated, but at the same time not so much that you're encouraging any future claims. Now, I think there's something that's worth thinking. Let's brainstorm this a bit. What if you offer a monthly sum, a single lump sum to cover all claims by the claimants, and plus maybe some non-monetary terms? For example, maybe you consider removing their specific works from your training data set, or paying a licensing fee for including these things. maybe including also a confidential apology or acknowledgement of their concerns. But this is strictly just between the parties that stays private.
Removing their works, technically it's possible to fine-tune or adjust the model to not replicate certain texts, but I think it's a bit complicated. But if it's a term, maybe we could agree to do that in the future. So a licensing fee going forward for their content is also possible, or perhaps giving them access to see what content was theirs and what is used and what is not, and they can opt out.
I am ready to commit to not use their future content without permission. However, as the training has been done, maybe we can retrain a new set of data to exclude their works. Maybe symbolically, or maybe we could install a filter that stops the output of their text. But moving on to the apology part, if it's a confidential apology, then we can do it, no issues. However, if it's a public apology, then it's a tricky situation. Because if it's a public apology, it will seem as an admission of guilt on our end. Therefore, a private apology in the form of, let's say, a written apology or a statement of respect, yeah, that's fine.
And in terms of the money, I think we should set a ceiling here, because internally we've actually discussed the rough figure, and given that the joint demand in the letter was extremely high, we thought a reasonable settlement might be, let's say, 2 million ringgit total, maybe to be split between Ms. Jennifer and the Daily Ledger. So we could start by offering them a bit lower than our ceiling, and then expecting them that they will negotiate up. So in that sense, we can have some kind of flexibility there, but not anywhere near what they initially asked.
Yeah, sure. Microsoft can contribute a share of that, as we agreed earlier. In regards to the split, we'll handle that. But yes, the rough figure that Sing suggested is also what we roughly think is enough or worth it to just avoid a bigger public fallout.
Okay, I understand that. And also, of course, I won't disclose your exact numbers, but it's very helpful for me to know the acceptable range what you guys are willing to give to settle this. Now, think about what else might make the deal acceptable for them, apart from that sum we just mentioned. For example, they seem to care a lot about their rights being acknowledged. Is that something you guys also realized? Yeah. So what if you include a clause in the settlement that acknowledges their intellectual property, and maybe something along the lines of Microsoft and OmniAI regret any inadvertent or indirect use of your data or your content, and we appreciate their contribution. So that is not an admission of guilt or illegality, but more of a statement to show that you're sincere and you are willing to compromise, and you ensure confidentiality of the statement so it stays out of the public eye. And also, if you realize Denise is the chief legal officer, she might appreciate a structured solution. So maybe you could offer something like a one-time payment and a limited license. Frame something like, we will pay an X amount of money for a license. In return, I could use those works to train the AI going forward. So that way, that framing, you are essentially buying a license after the fact rather than paying for damages. It could feel more acceptable and palatable to you, and to them it will still mean a compensation.
Yeah, that's smart framing. Yes, because wording does indeed matter. We could say that the payment includes a licensing component for any past usage without admission of any illegal conduct. But internally, we see it as a settlement. But on paper, it can look like we purchased their rights.
I like that. It protects the principle that we are not admitting to any wrongdoing, but essentially we are giving them what they want: money and recognition for their work.
And I think we definitely need a confidentiality clause. This settlement must remain secret, and they should agree not to do any public statement beyond maybe jointly agreed press release and so possibly no press release at all, just silence. If us, we could have a joint line like, the parties have agreed to settle this matter amicably.
Now that makes sense. Now, I believe if we can reach those terms, both sides would definitely want to keep it private. The unions, the press advocates, the public may ask, they may be curious, but I believe if the parties themselves don't escalate the issue, I'm sure it will clearly go away. Now, I think it sounds like we have a package that we can offer them, a monetary sum in the low millions, a commitment on handling their content, something like a removal or in licensing for future, an expression of respect or private apology, and a confidentiality clause. Are you ready to present something along those lines?
Yes, I think we might start offering, let's say, 1.5 million total, and we're prepared to go up to around 2 or a bit more. We'll also offer to implement measures regarding their content and provide perhaps a written acknowledgement of their concerns.
Yes, we just need to be a bit careful on how we phrase it or we propose. But since this is a mediation, we can speak frankly and then let the written settlement be carefully worded.
Oh, that concern is no problem. I will help make sure that the wording works for everybody. I can do that. One more thing though. Do I have your permission to float this idea with the claimants? Of course, I won't disclose your exact figure, but it could help me test the waters with them.
Yeah, you can convey that we are willing to pay a significant sum and take necessary action to address their concerns and to answer your question. Perhaps we can ask them what range they have in mind and we can see if it aligns with them.
Sure, I will do that. Because they did share some thoughts with me on what they find important. They give me a sense of what their priorities are and where the flexibility lies. So I'll be careful and get their reactions on these things. Why don't you all take a break first, and I'll bring everyone back to the room again for the joint negotiation.
Yeah, that sounds good. Thank you, Jordan.
Okay, I'll see you back there.
Okay. Thank you for your patience. Our private discussions have been very constructive, very fruitful, I believe, for all of us. And without breaching any of the confidentiality, I can say that there has been a clear willingness on both parties, in fact, to resolve the dispute, and it's very sincere. And I appreciate that. We identified the elements, the main elements that will be in an agreement. And I would like to summarize that into a possible resolution and see how all of you feel about it. Now, from what I've gathered, the proposal is that Macrosoft and OmniAI will make a one-off lump sum payment to Jennifer and the lecturer to settle all past claims arising from the AI's use of works. While the precise amount is to be determined, I would see it in the low millions rather than what we have initially demanded. And this payment will be framed as a compensation or as a license fee for past use, and it would not constitute an admission of their legal liability. Now, going forward, Microsoft and OmniAI would also agree to cease any unauthorized use of this protected content by the claimants. And in practical terms, what this means is Jennifer's novels and the lecturer's articles would not be included in their future AI training again. Without permission, and technical measures must be implemented to prevent reproduction of those specific works from this part. Now, if the claimants are open to this, the parties could later negotiate a limited license agreement on agreed terms such as royalties for any past use in the future. Otherwise, if this is not in place, in default, the content will be removed and filtered. But now, in addition to those things, although the respondents will not admit to any wrongdoing, they are prepared to acknowledge your concerns. Now, this could take the form of a written statement of acknowledgement, expressing regret for the unintended use of the materials, and just recognize the importance of your IP rights. If any public statement is required, it will be jointly agreed between both parties, simply noting that the matter has been resolved amicably and that innovation must be balanced with respect for creators' rights. Something along those lines, something neutrally worded. Now, the settlement, most importantly, will be confidential. I think this is of interest to both parties. In line with the Mediation Act that EAC mediation rules, the terms, including the compensation and even the existence of these terms, will not be disclosed, and the parties would agree to not make any further public accusations. And if anybody asked, a brief joint statement can be released, just confirming that the dispute has been resolved, and that would suffice. The agreement would also expressly state that the settlement is a goodwill resolution and not an admission of liability, and in return, Jennifer and the lecturer would release all related claims and agree not to pursue any claims and not to help any other parties pursue any claims in the future on the same matter. So these are the broad strokes of what a potential agreement would look like. I just want to check in here with Jennifer and Miss Denise. Is that something that you could agree on or accept in principle?
A few moments later.
So I would say in principle, yes. The outline does address our main concerns, and of course the amount will matter. We need to feel the compensation reflects the gravity of what happened, but the inclusion of future protection where they're not going to use our content without consent and a form of apology is very important to us actually, and we'll be prepared to accept a reasonable lump sum with those conditions. And the confidential is fine with us as long as we can reassure our supporters that our rights will be recognized. And I'll say the adjoint statement, like you suggested, could actually help with that. So,
Yes, I agree with Ms. Denise. We are broadly on board. So we would like to see a figure on the table to be sure that it is enough for us. Also for clarity, if a license framing is used, then we want it clear that it's a one-time license fee for past use, not an ongoing license that allows continued use without future permission. So future use should still require our say-so, unless separately negotiated.
I believe we could work that out later. Now, what about from the respondents?
Yes, absolutely. It will be a one-time arrangement where it will just cover past training usage, and going forward, we won't use your work unless you agree, or we could negotiate a new license in the future. We are comfortable putting that in writing.
Yeah. As for the figure, Microsoft and OmniAI, we already discussed and we are ready to offer 2 million in total to settle all claims. And this amount will be divided between Ms. Jennifer and the daily ledger in a way you find acceptable. So for example, you could either split it equally or in any ratio that you agree on.
Thank you for the offer. I think 2 million is much lower than our initial price, but we do understand that this is a compromise. So considering the speed and also the privacy of this resolution and the other terms, I think this is something that we can work with.
yeah, but however, we might request for a slight increase just to feel like we've done our best. So perhaps 2.5 million, that will significantly help cover our legal fees and also show to the stakeholders that we got a substantial outcome from this.
Okay, great. We kind of expected for you guys to ask for more. So with that in mind, we are prepared to offer Alan 2.3 million as a final price. And that amount can be divided to both parties for let's say 1.15 million each, or however you perceive it. We are trying to be accommodating here, but you have to understand that we have our budget to adhere to, as well as our boss to satisfy.
I guess that difference is small enough, Denise.
Yeah, I guess that works. We won't go over 200,000 at this point. 2.3 million, I guess we'll just split it half, it will work.
Well, that's excellent. I see lots of agreements all around, and I guess that means we have an agreement in principle. But before we do anything forward, let me just briefly summarize the final terms. So to make sure we are all aligned and this could be finalized. So Macrosoft and OmniAI will pay jointly a total of 2.3 million, with 1.15 million paid to Jennifer and the ledger each. Now this payment will be made within say 30 days of the written settlement agreement being signed. Well, going forward, OmniAI and Macrosoft will not use your novels and your articles and in any of the future trainings or products without your permission, and that could be sorted out later. They will also take reasonable technical steps to prevent these works from being reproduced and by the current AI model, and if they wish to use this in the future, a license agreement could be worked out. In return, Jennifer and the ledger agree that this matter is finally settled, fully settled. You will not bring any legal action further from this against the respondents, and you will not support any other similar claims. And most importantly, all parties agree that the settlement and the terms will remain confidential. As you said, I repeat it again. The fact that a dispute has been resolved may be acknowledged in public, but no details must be disclosed. Any public statement will be jointly issued, jointly agreed, and neutrally worded, like how we've explained earlier. And this agreement will clearly state that this settlement is not an omission of liability by Microsoft and OpenAI, and equally not an admission that the claimant's claim lacked merits. It's just a practical and amicable compromise to avoid going to litigation that will result in a public fight that doesn't benefit any of us. Now, finally, Microsoft and OmniAI will each provide an acknowledgement to you, to Ms. Jennifer and to Ledger, to recognize your creative works and express their regret for the situation. And I believe we could all agree that it may have been unintended, while affirming respect for your IP rights. But once this is signed, this mediated settlement will be legally enforceable, will be binding on all of you, and it is legally enforceable. It can be enforced under the Mediation Act and the AIAC rules. And if it is necessary, it may be recorded. We may record this as a contingent judgment in court, but I don't think we have to do that. We trust all of us to honor that promise.
So do I have your agreement on this?
Yes.
Wonderful. Now, as we conclude today's session, I just want to commend to all of you, Ms. Jennifer, Ms. Denise, Dr. Jabbour, Mr. Rizal, Mr. Julian, Mr. Singh, for joining us, for being such great participants. You've came to this mediation with a very serious conflict, and through conversations, through facilitated dialogues and compromise, you have reached a solution that you can all live with, and it's satisfactory to everyone. Now, this outcome, however just or fair it is, avoids a potentially long and bitter public fight. Instead of that, we are here to provide a closure, and we are charting the way forward for all of us. So I think that's important. Now, the next step is obviously to now reduce that agreement into writing. I will assist everyone in drafting that agreement. Now, once that is settled, I will ensure it's signed by all parties, and once it is signed under the Mediation Act, it is binding as we discussed earlier. We will also require to inform the AIAC of the outcome as required in the rules, but rest assured, they will keep that confidential as well. I sincerely thank all of you for your cooperation and the civility you have maintained. It's been a very pleasurable time mediating this. I congratulate you on this outcome, and thank you. And I declare this mediation now closed.
Thank you.
Thank you.